Okay. Hello, everyone.
Hi.
Hello, Susanna. Hello, everyone. We started the webinar. So I suggest we take about a minute or two to make sure participants will join. And maybe in the meantime, I can give a few words about how the webinar is going to take place and some practical things. So it's a webinar that has a questions and answers format. That means that participants can add their questions in the Q&A box. It will be recorded, so it will be available after the webinar as well. We will add it on our YouTube channel and our website. And we will also make a highlights video of it to where we will put the most important information from the webinar. So I suggest we get going. So I would like to welcome everyone to the first webinar of the series Intellectual Property Essentials, which is part of the iPower SME initiative. It's a series that aims to bring together SMEs, especially those in the digital sector, but not only, with experts that work in the area of intellectual property rights to share their experience with IP and give advice to those SMEs that are seeking to navigate this landscape of intellectual property. So for the first edition of the series, we will discuss about strategies for business growth and innovation, leveraging IP. And I have with me 3 professionals working in the sector from different areas of application. So I'm positive that their combined expertise will offer interesting insights on growing a company using IP assets. So allow me to introduce Susanna Grech de Gaura, Senior Associate at Chetcuti Cauchi Advocates. I hope I pronounced that well, otherwise I apologize.
Don't worry.
Susanna has a great interest in technology and has a marketing background, and she currently specializes in intellectual property protection. She's also an approved mentor with the Foundation Institute and delivers various workshops and keynotes on IP. We have with us Luis Sinafuku. He's a product innovative engineer at Rold in Italy and an intellectual property expert. His expertise lies in engineering, innovation, and protecting innovation assets through IP. And finally, Jente Tak, a European patent attorney at Brands and Patents, focusing on general engineering and in particular medical devices, mechanics, electronics, and textiles. So as you know, our discussion today will have the format of questions and answer sessions, and you already shared your questions for the experts in the registration form. So we already grouped and selected those questions that align the most with the topic of the webinar. But we also selected questions on specific business cases from SME. But before we start, I would actually like to set the scene by looking at the current situation of SMEs in the EU to provide some insight into why companies register or don't register intellectual property rights and what problems they encounter when doing so. So you'll see now on the screen a few numbers. So according to the data of the IP SME scoreboard released by the European Intellectual Property Office in 2022, after registering their IP rights, 54% of owners claim to have seen a positive impact. And the main impacts identified were increased reputation, with 52 of the respondents selecting this impact, turnover 39%, and ability to access new markets 37%. For those SMEs without registered intellectual property rights, the main reason for not doing that was a lack of knowledge about what IP is and what's its benefits. The percentage of respondents giving this reason has grown from 25% in 2016 to 38% in 2019. And only 25% of medium-sized IPR owners have professionally valued their intangible assets, and this number drops to 20% for both small and micro-sized IPR owners. And finally, although access to finance is one of the biggest issues for SMEs, only 13% of IPR owners have attempted to gain financing using their intangible assets. So this is what the numbers say. So I suggest now we get going and start our Q&A session to hear about the concrete challenges and opportunities encountered by the SMEs in our network and the advice of our experts. So to start, to consider what are the best strategies, SMEs should look at what IP protection is available out there, especially when it comes to digital products. And one of the participants even asked if it is realistically possible to secure intellectual rights for products in the age of the internet. So I would like to ask Susanna to give us a brief overview of what IP protection is available.
Sure, and welcome to everyone. Basically, there are different types of IP rights that are available, and I thought that the best way to start this off is basically to give an overview of the different types of IP rights available together with my colleagues. So the first and perhaps most obvious IP right available is trademarks. It is any sign or logo that is capable of distinguishing a good from another or a service from another. There is a process to get it protected, and once you have the certificate, you have a clear protection of the logo, name, or your composition of both. With regards to the digitalization and digital products, it's interesting to note that together with registering a name for a company, a word mark, you can also register a domain name. However, it needs to be a domain name that is distinguishable, that is already known as a domain name. For example, bookings.com. It's inevitably that we use the whole domain to be able to identify the platform. So in that case, and cases where the domain is a part of the name and identity of the business, there you can register a domain name as a trademark. Another type of IP rights available is a design right. So basically, a design protects the appearance of a product or a part of a product, of a particular contour or shape of a bottle, of a shoe, and texture or material. Perhaps this is the most unapplicable when it comes to the digital sector. However, I have assisted a couple of clients who acquired design marks for their avatars and their main characters in online games and all that. So there is also the third type, which is trade secrets. Basically, a trade secret is not registered anywhere in the sense that there is no process and you'll get a certificate at the end of it. And there are three main requirements to have a trade secret. So basically, it needs to be a commercially valuable secret. So it needs to be something that if disclosed, anyone can make money of it. It needs to be known to a limited group of people, and a company who has a trade secret needs to take reasonable steps to ensure that the trade secret is actually protected. So if it's something that the company, you can find it on their About Us, of course, it is not a trade secret.
Okay,
I understand exactly that. Will be going. My colleague Jente will be going through patents.
Yeah, thank you, Susanna. I'll quickly jump in on the other sides then of the intellectual property rights, and especially with relation to trade secrets, you have the other side that is a patent protection. So patent protection is the functionally directed brother of designs and trademarks, etc., where trademarks and designs are focused on the aesthetics, I'd call it. Patents go into the technical story behind it. So a trade secret is part of that field sometimes. So in these technical inventions, there's always the discussion: should it be patented, or should you keep it as know-how, as a trade secret? Patent protection exists as a way to reward you for sharing your innovation, for sharing your technical breakthrough with the world, and in exchange for sharing your knowledge, you get a certain monopoly right, a right to forbid something to other parties. Of course, that's limited in time, only 20 years at max, where trade secrets can sometimes be, if we'll just look at Coca-Cola, for instance, just a couple of days ago, I saw the vault with the secret, the figure of it passing by. So that can last for as long as you keep the secret well enough, I guess. And then perhaps one of the also important rights in terms of digital patents can be copyright protection. So if you're talking about software development, you have kind of a de facto protection immediately upon writing code. Basically, you protect that code under copyrights. You can also register it officially, but there's in principle no need to do so. And patents kind of share that ground in terms that copyright for software can very specifically protect the source code of an idea, while patents are there to protect the general concept behind it, so the functional idea behind it.
Okay, thank you so much, Jente. So one specific question that we received from one of the participants is that, could you please provide the definition and explain the usage of utility model as an IPR tool for software? So I would like to, Luis, maybe to pass this question to you.
Yeah, perfect. Thank you. And good afternoon to everyone. So first, I think it is important to understand a bit more about what is an utility model. Already the other experts talked about other different types of intellectual property rights. Now we can talk a bit about utility model. A utility model is a form of intellectual property right with some difference with respect to a patent. First, we can talk about the advantages. The advantages are that the utility model has to comply to lower requirements in terms of the level of innovation. Another benefit that can be very applicable in this case with software is the fact that there's a simpler and less expensive procedure to obtain the utility model. This in the fast evolving market of software could be very relevant. Now, let's talk about disadvantages. The big disadvantage of a utility model is the fact that the period of protection is lower compared to a patent. At least, for example, here in Italy, the protection of a utility model is limited to a maximum of 10 years compared to the 20 years for patents. Now, talking specifically about the software part of the question, let's first start explaining about patenting software that Jente already explained a bit. Here in Europe, it is not possible to patent software as a computer program itself, but this can be circumvented because normally software here is patented as a process or as a method patent. Therefore, now talking about the specific case of utility models, the idea to protect software through utility models would be similar as the patent idea. Is the way to protect your software through protecting a method or a process. And this is kind of tricky because it depends on each country where you're seeking protection if this kind of protection is allowed or not. For example, here in Italy, it is not possible to protect methods or processes through utility models. So in our case here in Italy, the only way to protect software will be already, as Jente explained, through copyright, or rather through a patent that protects the process or the method. In contrast, for example, I know that, for example, in Germany, you are free to protect methods and processes with an utility model. So it is important to understand which market you are trying to target, and therefore which market are you trying to seek protection for, and then understanding how are the utility model rights defined in that country.
Okay, great. Thank you very much, Luis. Now we have an overview of the IP protection options. So let's go to the companies. When it comes to understanding what are their IP assets, how to define the IP portfolio of a business. And I'll pass these questions to Jente.
Yeah, thank you. For each company, it's entirely dependent, of course, on their situation. If you're a startup, if you're already an established company just trying to pivot into a different direction. So let's assume that we're starting quite early in as a company. First of all, I think it's crucial to get a roadmap for your next 5 to 10 years, basically. Seeing what kind of product or method you're going to start commercializing, what exactly is the concept you're trying to monetize, and in which regions are you going to try to commercialize your products. Based on that, you can only start evaluating what you should be protecting. And following on that, you can start thinking about how you can protect it, whether it's via trade secret, via a patent protection, just plain old copyrights, or something else. Usually, it's a mix of, well, a mix of several of these intellectual property rights. You want to both protect your name, you want to protect your logo, but you should definitely protect the methodology behind your product. Once you've established that, you need to take into account what your exit strategy is as well. As a startup, are you looking at an exit strategy in 5 or in 10 years? Do you need IP for that? That's a very important question to ask yourself, because it's a costly affair, IP, especially if you're talking patents, because it's a long-lasting procedure and the cost up front is big, but it doesn't become cheap in the following years. So it's difficult. You need to protect yourself from getting burned, basically. So if you can plan that out in phases up to a certain commercialization point or exit points, then you can basically build out your IP strategy for the next decade. Another very important thing to consider in this is, and something that we see is missing in a lot of startups and small and medium enterprises, that you need to have a specific contact person for this. Not a contact person necessarily, but someone whose responsibility it is within the company to handle these things. What we see a lot, we work as outside consultants a lot for companies. What we see a lot in companies is that it becomes an added task for someone who's seeing it as as something extra to do on top of his regular job. So it always becomes a second place action. What we think is crucial is that it becomes a real part of a job description, so you can give it the proper attention that it needs to have a well thought out strategy there.
Indeed, and I think a part of this strategy is also having the right human resources in your company and keep them informed and trained about this part of your business. Okay, now I would like to follow up with a very specific question from one of the participants. They say, we founded our startup and have duly registered as a company in Italy. Later, we tried to file our trademark and a problem arose that forced us to face an expensive rebranding. What is the correct procedure when I have to found a startup? So I would like to pass this questions to Luis, because he will also share with us a tool that companies can use, or a method when looking to found companies and assess what is the IP already registered in the market.
All right, thank you. So this is actually something that happens very often with small, medium companies and startups. So my recommendation in these cases where there's a case of IP rights, it's always important to, at the very initial state, to check already what's already out there on the market and also registered, or also on some patent database. So in the case of patents, it is necessary to do a preliminary search to understand what you can find in the state of the art. There's many free tools that are available for the use on these kind of searches for patents. In the case, in the very specific case from this question, so in the case of trademarks, it is necessary to check which logos, which brands, which words are already being used in your field and are already registered. So in this case, I would recommend to use some tools that are available. For example, the WIPO has this global brand database, or the European Union Intellectual Property Office has its own tool called TMView, where you can basically search for brand names. You can do a search for logos by uploading an image. So I think it is a really complete tool to do a preliminary search for this kind of trademarks. Now, as Loredana introduced, talking about surveillance of existing IP, in the case of patents, I want to present really briefly a tool that was developed internally in our company. So I will share the screen, and on the meantime, I will give a small introduction. So basically, why did we develop this tool? So basically, in our company, there's a really big importance in this kind of preliminary researches, especially for patents for our R&D department. So in our case, we used to have an external consultant that every 3 months shared with us a report where he basically collected all of the patents published by our competitors and prepared a document where we could see them. Now, the problem is that we have some competitors that, of course, they produce some products that are similar to us, but they also produce many products that are completely different from ours. So at the end, we got this report, and it was filled with some documents that were not relevant at all for us. So in this case, we decided to develop an internal tool for internal use that was able to give the possibility to a user, even if it's not really experienced with doing patent searches, to retrieve the relevant patents from our competitors. So this is the interface that was developed for this tool. As you can see, first you can select the name of the competitors. For this presentation, I'm using very generic names as competitor 1 to 6 for privacy reasons. But first you select the competitor names, then you move forward and you select which kind of products are relevant for this search. We as a company produce electromechanical components for home appliances. So you can see some of the products that could be relevant for us are door locks, door latches, door openers for the different doors of the appliances, or for example, rotary switches. In this case, we selected 3 of these products. And finally, we select the date range that we want to use for this report. And as an output, this tool generates a query with the inputs that we have given it, and automatically does a search in a patent database and retrieves the information from it. So at the end, you obtain a file where you have first the patent, the full number of patents published by our competitors. And we can see that in this case, we had 113 patents in this data range. And this would be very similar to the report that we would have obtained from our external consultant. And on another page, you can see the patents that are only relevant to the products that we selected on the user interface. So you can see here we only have 17. So this means that with this tool, the R&D manager can focus on these only 17 documents and does not waste time by checking all the almost 100 documents that would have been appearing on the report done by the external consultant. Now, with this same logic, this was already very appreciated internally, but with the same logic, we wanted to go a bit farther. So we developed a similar tool with a small difference in the sense that we are not focusing so much on the surveillance, but we developed a tool that uses the same logic to analyze the trends of the patents. In this case, the user interface is really similar, but in the first step, you select the clients and not the competitors. Then you have to select the market sector and not the products. So in this case, a market sector that could be interesting for us would be the washing machine sector. And finally, again, you select the data range, the date range that you want to analyze. And as an output, again, you obtain a query that automatically gets used in a patent database search. And we obtain, again, a big file with a lot of patents retrieved with the specifications that the user used in the user interface. But in this case, we want to focus on one data in specific, that is the International Patent Classification. This code can give us information about the topic that is being covered by the patent document. And this tool allows the possibility of generating this kind of graphs. We can see that here we see how is the trend going for some specific IPC codes. So for example, in this range of dates, we can see that the improvement of operational steps depending on the condition of the laundry was something that is increasing in importance in the research and development efforts of our client companies. So this kind of information is something that is really important for our sales and marketing departments. And all of this can be retrieved thanks to an intelligent use of IP data that is public and available for everyone. So this is an idea of how a small or medium enterprise can use this kind of data.
Thank you very much, Luis, for sharing with us the tools. Just a quick question. Are you planning it to make it available eventually to other interested parties, or you're going to use it only internally?
Yeah, the idea would be to make it available for other companies. But for now, we are on an initial phase where we are still testing the results. For now, the results have been very good, but we're still evaluating them.
All right, thank you. So indeed, a very important step is to look at what is already in the market to make sure you don't infringe IP of other companies. Then I would like to go to a question very specific again, which is your approach in identifying know-how elements which should be protected as trade secrets. How do you define the content and limits of such trade secrets? And what are practices, what are in practice the methods used to ascetize them and actually protect them? So I would like to pass this question to Susanna.
Yes, thank you. Something to start off with to set the scene on this is there is no EU-wide legislation when it comes to trade secrets. So it is generally based on national laws. The Convention for IP Rights, the Paris Convention, does mention trade secrets, and it does put the onus on all the member states to protect and to provide effective protection to trade secrets. However, there is no EU harmonized law as to the process of obtaining and registering a trade secret like there is with patents, trademarks, and the rest of it. Essentially, as I already said in my initial comments, there are three main requirements for a trade secret, it needs to be commercially viable, limited, and also kept secret. Perhaps with regards to the actual protecting of the trade secrets, given that you don't actually receive a certificate at the end of some kind of registration process, as Jente already said, it might be a bit more difficult to be able to claim your trade secret has been breached and the rest of it. However, there are some best practice guidelines which can be used. So, for example, one of the most important thing is to establish the appropriate policies and documents internally and externally when it comes to the protection and confidentiality of intellectual property, even with employees and internal staff who may, from time to time, work within the parameters of the trade secret. It is always important also from a practical point of view to limit the amount of people to whom the data is disclosed, to ensure that you have a small nucleus of people who are aware of the contents of the trade secrets. It is also important to establish security measures beyond contractually and legally, but also physically. So as Jente already said, the infamous Coca-Cola trade secret is very, very well protected. They have a high security vault. In Georgia, there are only 2 employees at a time who know the actual trade secret, and they never travel together, so they never fly together. So they go to great extents to protect their IP rights. It is also important as well when you have some certain documentation that make even the slightest reference to the trade secrets, to label them all as confidential and treat them as confidential information. That is also very important.
Okay, great. Thank you so much. So to wrap up this part on ideation and strategy at the moment of considering what IP assets companies can exploit, I would like to ask each of you, what do you think are the 3 go-to steps for a startup when setting up an IP development strategy? So maybe I can start with you again, Susanna, since you had the word.
Yes, of course. Basically, what I would say is from my end, especially with regards to IP, which I generally work in most, is to search before running after an idea, to get to know the market, even when it comes to trademarks and designs. Go out there and search what's out there already, and keep in mind the eligibility from a formal point of view. So there are some laws which actually stop you from doing some things, even if it's not an issue of similarity. So those, I would say, are the most important things from my end.
Thank you. Jente, would you like to share your advice?
Yeah, like Susanna just said, think about what you want to do your proper research yourself first. Think about what you want to protect, and then do both reviews. Can you protect it yourself? Like, for instance, via a patentability study, check if it is new, if it is inventive, so if you can actually protect it. But also think about the other side in terms of freedom to operate. Can you actually commercialize the product without falling within the protection of a competitor? And perhaps one of the most important takeaways, if you would fall into the protection of a competitor, don't just stop. I mean, think on how you can adapt, think on how you can improve, and try to find a cooperation with them, for instance, via cross-licensing. And perhaps the last step, especially for small and medium enterprises, think about your budget. Talk with your IP provider and get a clear view on how much it will cost down the line. Not just right now, but ask how much it will cost next year and the year after, so you don't overextend and suddenly you can't protect something that is crucial at a later time.
That's great. That's a very valid point, because especially for SMEs whose resources are limited compared to bigger companies. How about you, Luis? What would be your take on this?
So for a startup especially, they normally collaborate with incubators or with big companies that help them develop. So with this in mind, an important step in these cases is to clearly define from the very beginning of the collaboration about the management of the generated IP assets. So for example, it is important to define clearly who will own the generated IP, or how will the revenues generated by the IP will be distributed between the two companies and the startup, for example. I think this is really fundamental point in this kind of collaborations.
Again, a very valid point, and I think it links very well with the next steps, let's say. So, having talked about the strategy, I would like us now to go more into the business development phase. So, looking at the options to grow a business, what are the options currently that are again out there to do that? So I would maybe like to ask Susanna to start sharing her views, and then I will also ask Luis and Jente to share.
Yes, I think especially a lot of startups and smaller businesses have so much going on that IP is generally the last thing on their mind. But if you keep in mind, there are a lot of advantages when it comes to having your IP from very early on. A very interesting study that was done by the European Patent Office and the European Intellectual Property Office is that startups and SMEs, which already have some initial kind of IP protection, are 10 times more likely to secure funding. And this is something, it's when a startup and an SME understands the benefits of having their IP in place, it becomes kind of a no-brainer. But until you get there, it also increases the company value, given that it also is an asset for the company. And lastly, I would say it also opens up to the world of licensing, which is and can be a new income stream for the company.
Would you like to add your view on this?
Yes, so for sure. As a practical example, our company has participated in many regional or European funded projects. For this kind of funding programs, IP assets are really fundamental. And in our case, we can use them to demonstrate the commitment of the company with innovation. And this gives us higher chances of getting financing from these programs. So I can testify for how useful can it be to use your IP as a collateral for financing as a small or medium enterprises here in Europe.
Niente, would you like to add on that?
Yeah, what I see personally in terms of patents, of course, then is that it can get you a seat at the negotiation table. Basically, as a small company, talking to bigger players, you need to be sure that you have your own rights secured before sharing everything. So getting some protection, patent protection, or whatever, is crucial in that perspective. And a further reason why you should also look at patent protection or other IP rights is patent box regimes. In many countries in Europe, I mean, I think Germany is one of the few exceptions on it, and even then, there's a strong tax incentive towards getting IP rights.
Okay, thank you so much. Then we received another specific situation from one of the SMEs, and they asked, if you conduct an FTO, freedom to operate, and the result is negative, for example, there are certain risks that the innovation is covered by patents, what are the next steps to exploit the innovation? So I will also leave this to Jente to respond.
Yeah. I mean, if you do a thorough enough freedom to operate research, you will always find some troublesome documents. Like I said before, it shouldn't stop you entirely from proceeding. It should make you think about what you can do to perhaps, adapt around the patents. It can lead you to interesting insights on how to further improve on a concept. That could give you cross-licensing perspectives with your competitors. I mean, you shouldn't just stop entirely, especially in view of which right it is. If it's a granted patent, you should, of course, be more careful. If it's a pending application, then you need to be aware of it, but don't stop entirely because you might infringe.
Okay. Then going back on the situation of collaborations, another question we received is, are there any best practices to govern IP ownership in entities with distributed ownership, such as digital platforms or cooperative SMEs? Luis, would you like to share from your experience on this matter?
Yeah, sure. Personally, I have not worked with a cooperative SMEs, but as a company, we have to deal with a lot of topics of shared IP ownership, working with big companies and also a lot with universities. And as I mentioned before, it is fundamental to define clearly the ownership of the IP and how the distribution of the revenue will be done. But as a specific case, I would like to mention the case of working with universities. It is also fundamental to define a procedure for the disclosure of the invention. So basically, the university has a goal of developing and sharing this kind of knowledge. So in the case of an IP collaboration with a university, it is necessary to clearly define the procedure for the disclosure of the invention by the university. For example, maybe defining a model for a non-disclosure agreement, an NDA, to be signed every time that the invention is disclosed by the university could be a very important step in these kind of cases.
Great. Susanna, would you like to add something here, maybe?
Yes, maybe, especially with regards to the contractual requirements in this sense. It's also very important to put everything down in writing to the smallest detail, even though it might seem useless at the time. Something I will also add, which might sound a bit controversial, is don't recycle. In the sense that if you're doing contractual agreements which are tied to a particular jurisdiction, it generally doesn't make sense to use them in another jurisdiction, because national laws, although most EU countries are civil in nature, but jurisdictions have different laws, and it might be that what is applicable and enforceable in one state is almost useless in another state. So that is something I would add when it comes to interstate agreements, and also to read thoroughly what you're about to sign. So that's something which is, I think, is very important.
Then going back to the topic of financing, so what options are there to fund IP related services? I know with Jente, for example, we were talking about tax incentives. Would you like to share more about that?
Yeah, sure. Like I said, most countries, well, most European countries have an IP box or a patent box regime applicable. I see Susanna nodding, but I know that Malta has one of the biggest advantages actually.
Yes, yes, you do.
I was quite surprised by the extent to which it went. But for instance, in Belgium, normally companies are taxed at 25%, but via the patent box regime, they can go as low as about 3.75%. This is why the really big pharmacy companies are based in Belgium because of this regime. I don't want to advocate using it just because it's there, but it's certainly something to take into account when you're protecting. There's a real remuneration project available that can quite easily recoup you all the money that you spent on development, and especially on the costly IP procedures. So certainly something to look into.
Thank you. Luis, what is your experience there?
So adding up on what Jente already mentioned, I would like to add that in the case of small and medium enterprises here in Europe, there's many possibilities to access some funds that are granted to support the cost associated with IP. In our particular case, our company has access in the past to some grants given by governments of our region that basically almost at 100% fully cover the cost of the patent drafting and the cost of the patent application. Basically, these kind of grants have the main requirement that the patent is related to a topic that is relevant for the region. So, for example, in this kind of grants that we have participated in the past, some of the general topics were, for example, reduction of food waste or development of cleaner ways of transportation. So, in conclusion, there are a lot of great opportunities to obtain funding for IP-related services as small or medium enterprises.
Indeed, and we will talk about these opportunities more in detail in our next webinar, which will be focused only on funding opportunities for IP rights. So now, again, to wrap up this part, one important element is making sure that your IP is respected. So the final question here is how to be prepared to enforce your IP rights if necessary. So I would maybe ask Susanna if she has any advice there.
Yeah, so essentially before starting off, we need to distinguish between the IP rights that offer you an actual certification, and there's a process like patents, trademarks, and the rest of it, and others like trade secrets and copyright, which there is no actual process you can do. Of course, after you register a trademark, it's always your responsibility to monitor what's going on the market to make sure that no one is infringing your rights. First thing, always, if you see that someone is trying to infringe your rights or anything like that, is to start off with negotiations between the parties. Generally, it is in that way that we're able to solve these conflicts by kind of coexistence agreements and maybe even licensing agreements between the two. Then you can also make use of alternative dispute resolution platforms, which can help solve the problem without the costs and the time frames that going to court entails. And of course, then the last option is courts, either national courts or also EU with regards to EU IPO matters as well, and trademarks and patents. So that is the process to enforce your rights.
Okay, that is great to know that there are different methods, which are some of them not very expensive for SMEs to access. Okay, as we are approaching the final 5 minutes of our conversation, I will like to take only one more question. And that would be, what are IPR best practices for pro bono projects? How can we protect IPR when working with success stories in media? What are fundamental must-haves for this? I know, Susanna, you have some experience in this area, so I was wondering if you want to share your advice.
Sure. So essentially, pro bono and NGOs are crucial, right, in social spheres, and they contribute to society. I would say that there are a couple of reasons as to why an NGO or someone who is doing a pro bono project must have his intellectual property protected. Very briefly, it's first off to protect your identity. So especially if you're doing a pro bono project or you're an NGO, you need to make sure that no one rides the wagon, right? So it's very important to protect your entity from misuse, basically. Secondly, it's with regards to exclusive control, so that you make sure that you have complete control over the people representing the project or the NGO. Third one, and perhaps I would say more importantly when it comes to pro bono, is it gives you recognition and credibility. So it will help you stand out from the crowd in the sense that you're serious and that you take your NGO and your image very, very seriously. And also in some cases you can license out pro bono projects for others to also contribute to the source. So I would say that those are the benefits for best practices and IP protection for pro bono projects.
Okay, thank you so much,
Pleasure.
all of you. So I think we can wrap up this session here, and I will give you some updates on what are our next activities in the framework of this project. So again, thank you to the participants for sharing their questions and experiences with us, and thank you to the experts to give the advice and the insights from their experiences. So if you want to stay in touch with the experts, feel free to contact them via LinkedIn. You can also find their details on our event page. In the meantime, the next activities that we will organize are on the 7th of May. We have the second webinar in this series where we will go into more details on the topic of funding opportunities for SMEs linked to IP. Feel free to join already, so you can already register for the event and share your questions with the experts we will invite for that webinar. Also, if you wish to contribute to the knowledge ecosystem for SMEs regarding IP, we currently have an ongoing call for best practices to share insights and strategies that have proven effective in the area of intellectual property from SMEs in our community. So if you have an example of such a best practice, you're more than welcome to submit it at the link provided here on the slide. And finally, if you yourself offer support services or legal advice for SMEs, I would like to invite you to register your contact on the stakeholders map we did. It's a list with potential collaborators and IPR support services at national levels. for SMEs to connect with like-minded partners, to explore potential collaborative opportunities and access a series of support services that is tailored to their needs at national level. So this is it on our side. Thank you again for your participation, and I really hope to see you during the next webinar series. I'm really happy to stay in contact. If you have more questions about the iPower SME initiatives, or if you want to share anything of use for the SME community, you are more than welcome to contact me at the email address here. Okay, so I see very quickly in the chat, I will share with you after this webinar the links, the recording, and any other materials that might be useful for you. So thank you all, and I hope we stay in touch.